Hi, guys. Or CJ. It's me and you. Just me and you, CJ. We're alone. Welcome to OJ. Ah, there's Ginny and Terry. They both came in at the same time. Boom. Hi, guys. Terry, I like your new icon. All right. Time to start OJ. Time to get back. We're so deep in it now. I can't wait to get to the defense side. I'm like, I've heard enough from the prosecution, even though they really haven't said anything. They haven't showed me OJ did anything yet. A little bit. Just a little, I mean, my mind's there a little bit. But hey, Martha, let's get to it.
First of all, Mr. Park, when you saw the garment bag on June the 12th, you picked it up, did you?
Yes.
You loaded it into the trunk?
Yes.
Did it seem to contain clothing?
It seemed to have something in it.
Have you looked in this bag today, sir?
No, I haven't.
I'm zipping it. I'm going to ask you to tell us. You see any clothing in it now?
No.
You know what happened to the clothing that was in it on the night of June the 12th?
No.
You know where this bag has been since June the 12th?
No.
You know what happened to the items that were inside it?
No.
Did you see the contents of that bag on the night of June the 12th?
No.
And the golf bag that you were shown? I believe you indicated that exterior didn't look like the exterior you recall seeing on the night of June the 12th. You recall that?
Yes.
So do you think it was some other kind of exterior that was over the golf bag that night?
Yes.
And that exterior part, that sheath that you're describing, was that the part that you actually had contact with when you gave it to the sky cap and saw it in the trunk?
Yes.
And this black duffel bag, sir? Did it appear to have something in it on the night of June the 12th when you loaded it into the passenger area of the limousine?
Yes.
You see anything in it now, sir?
No.
You know what happened to the contents of that bag?
No.
You know where that bag has been since June the 12th, sir?
I have no idea.
Or what happened to the contents of the bag that were there on June the 12th?
No idea.
When the defendant got out of the limousine at the airport, sir, were there any of his bags left in the passenger compartment?
No.
Were there any of his bags left in the trunk?
No.
I have nothing further.
All right. I take it you do have some recross?
Yes, I have some.
Okay.
You like to do that?
No, we're going to take a recess at this point. All right, ladies and gentlemen, we're going to take a recess at this point. Please remember my admonitions to you. Don't discuss the case amongst yourselves, form any opinions about the case, conduct any deliberations, or allow anybody to contact you. We'll be in recess until 1:30. I'd like counsel here at 1:30. Mr. Park, you're excused until 1:30. All right, please remember my other orders. right there. All right, back on the record in the Simpson matter. All parties are again present with the exception of Ms. Clark. Mr. Cochran, you wish to be heard as to
Yes, Your
this
Honor, I'd like to be
other,
heard if I might. I'd like to ask leave of court to be able to ask Mr. Park a question regarding this particular bag, which I'd like to mark, and ask him whether or not this particular bag I have in my left hand here appears similar in size and shape and color to the bag that you saw from about 20 feet on the driveway. I think that this bag belongs to Mr. Simpson, and may have been one of the bags that he took to Chicago on that night. And the court is aware also that Mr. Park has previously seen this bag and indicated that it apparently comports or is similar in size and shape and color to the bag that he saw from some 20 feet away. You can't say definitely. And I ask leave of court in view of the attack taken by the prosecution regarding this bag to be allowed to ask that question in the presence of the jury.
Mr. Darden?
As I understood, the offer of proof counsel made at sidebar, it was that Mr. Simpson said that the bag might have been a bag he took to Chicago. He doesn't know. He can't say for sure. He thinks it's his bag. He has a lot of bags. Well, that doesn't give. That's no offer of proof. That's not much more than speculation. It's a complete non-committal on the part of the defense as to whether or not that bag is the one that was taken to Chicago, and they ought to know. To just throw things up here in front of this witness. Right, I believe. Well, the
No,
witness has seen
he's
the
already been
bag.
interviewed in the presence of counsel.
There's a little more than trickery. Beyond that, the bag is new. It is apparent that nothing has ever been placed inside the bag. The keys are still attached to the bag, and the little plastic string that once to which was once attached the price tag, I guess, is still on the bag. The bag was recovered just today, I believe, at 11 o'clock this morning from Mr. Kardashian's home.
Yesterday.
I'm sorry,
Yesterday.
yesterday. It's irrelevant. It's completely irrelevant. This bag it helps us. It does not help the jury. And as Ms. Clark has reminded me, there could be millions of bags that perhaps fit the description given by Mr. Park. And Mr. Park has told the court at sidebar, and he's told the jury as well, that he did not get a good look at the bag. His memory is somewhat vague as to what the bag looked like exactly. I mean, it could be, it couldn't be. Where does that get us? How is that relevant? And so we would object to presenting that bag to the jury.
The idea that it's very hard for the prosecutors to ever argue anything without labeling everything. The trickery comes from these vague theories that change, like the weather. All we're
Objection.
asking to do.
Is that not a gratuitous personal attack?
I'm
Your Honor?
I'm referring to his remark about
Counsel,
trickery.
stop. They'll see you.
Your Honor, the court pleases, I'm asking leave of court based upon the representation we gave, based upon the fact this bag was recovered by Judge Wong yesterday, to be able to ask Mr. Wong regarding this. This matter was brought up by the prosecution. They made great statements. Your Honor, could Mr. Darden please sit down and stop making sounds while I'm.
That's true. Why don't you have a seat, Mr. Darden?
Was I making sounds? I'm
Yes,
sorry.
you're going, It's a nervous. Yes.
No, I was going,
Would you sit down? No, it's that nervous twitch, so please. May I?
I thought it was,
It was, But it was Your Honor. Yeah.
I
Now,
couldn't believe it.
okay. Now, Your Honor, may I proceed? With regard to the prosecution's questioning of both Mr. Park and Mr. Cato Kalin, in this instance, all these bags were recovered. They were not recovered by the people. These bags were brought forward by the defense, the help of this court through the special master, and they're now in the court's custody. I want merely to ask the question the court knows that I want to ask. I've asked Mr. Park. It has probative value. It doesn't go to any weight. It goes to doesn't go to admissibility. Rather, it goes to any weight. Everybody knows he was 20 feet away. He was 20 feet away when they were asking all those questions too. But I mean, fair is fair. You can't allow them, it seems to me, to do all these things and not allow us an opportunity to show what might have very well have been the bag. And that's all we're asking to do, Your Honor. I think it's entirely appropriate. With regard to the other bag he can't identify, I'm not asking anything regarding that. And I'd like to conclude my cross-examination with that.
Mr. Darden, you
Your
wish-
Honor, this offer of proof does not rise to the level of what very well might have been. Mr. Simpson knows which bag he took to Chicago. He hasn't said that this is the one. And given that, the defense should be precluded from just throwing things up here in front of the witnesses. I mean, they throw theories around the courtroom, regardless of whether they have a factual basis for them. And now they want to do the same thing with this bag. It's irrelevant. It has no probative value whatsoever. So Mr. Cochran's making sounds behind my back, Your Honor.
All right, gentlemen.
At any event.
All right, thank you. I'm going to sustain the 352 objection for this reason. The offer of proof was this could possibly be, and the statement by Mr. Park with counsel at sidebar that does not look familiar, but he couldn't tell. You have, it's too speculative at this point, and the danger of misleading the jury is apparent, and the court will sustain the objection.
My understanding regarding what Mr. Park said, this is Mr. Park said. It's my understanding, Mr. Park, and I asked the court to ask him, what he said was that it was similar in both size, shape, and color, and that he was 20 feet away.
His initial comment to me was it doesn't look familiar.
But he did also say in his second
Counsel,
comment
I've got
that
8 bags in my chambers that are the same general color, general size.
8?
8. You want to count them?
No, you're not leaving count. But I thought, I just want to make sure.
2 just for DNA materials.
I want to make sure the court was mindful of what he'd said in the second part of his question.
I did. I heard very carefully. I listened to Mr. Park very carefully. All right. Thank you, counsel.
Because there is the issue of the other bag, right? The suede one.
That's not being offered, is my understanding.
Okay.
Mr.
The suede.
This-
Mark, this 1066.
Yes, for the record.
Okay. The suede bag is not being offered.
All right. We ready to proceed? All right. I do still have Judge Wong here available, but he would like to get out of here as soon as possible. Judge Wong is still here. He would like to leave, though, because he has other appointments.
If we could just drag out the
All right. Let's have the jurors, please. Oath, please. Couple of questions, Ms. Clark.
Thank you. Good afternoon. Mr. Park, when the defendant went over to the Sky Cap, what did you do?
I put the golf bags on the bigger, larger Skycap cart and the designer bag.
Okay. So you actually lifted that golf bag, did you?
Yes.
I'm going to ask you now to lift this bag for us and tell us if this is the approximate weight of the bag that you picked up and put on the Sky Cap's carrier.
It's close to it, yeah.
And now this bag, sir, go ahead, take a seat. This bag, who took it out of the trunk of the car when you got to the airport?
From what I remember, Mr. Simpson.
And who put it, taking it from the trunk, who put it onto the luggage carrier that you brought out of the airport?
I was holding the luggage carrier and he set it on the rack.
And when he picked up that bag and took it out of the trunk and put it onto the luggage carrier, did he complain to you of any pain in his arms or his shoulders?
No, he didn't.
When Mr. Simpson was over by the Sky Cap, sir, did you see, other than the garment bag and the golf bag, did you see where?
Remember? They said he had arthritis so bad that day that he couldn't have done it.
The other bags were?
From what I remember, there was, he had the one over his shoulder, and there was another one sitting on top of a trash can next to this Skycap stand.
So there was a bag sitting on top of the trash can next to the Sky Cap stand?
Yes.
Did you see Mr. Simpson do anything with respect to the bag on top of the trash can?
No, I didn't.
After you got Mr. Simpson over to the Sky Cap area, that bag was on top of the trash can, and the garment bag and the golf bag were given to the Sky Cap. What did you do?
I walked over to him, and that's when I was getting ready to leave, and shook his hand, said I had 20%, and that was it.
So you left at that point.
Yes.
Did you see Mr. Simpson enter the airport terminal?
Oh,
Not at that point. When I got back into the car, after I checked the car to see if he left anything, I drove away, looked down the terminal, and he was on his way to the airport or to the plane.
Did you see what he was carrying?
No.
Mr. Cochran.
So as I understand your testimony, Mr. Park, good afternoon, first of all.
Good
Ladies and gentlemen. As I understand your testimony, basically the last thing that you did with Mr. Simpson was you shook hands with him, and then you took your leave. Is that correct?
Correct.
And you'd had a rather pleasant encounter with him. Is that a fair statement to say, based upon the fact you got in there on time and everything went well?
Yes.
And in fact, he had said to add 20% to the bill, right?
Correct.
And first of all, with regard to the golf bag that was taken over here, this was the first night that you had ever seen Mr. OJ Simpson. Is that correct? In your life on June 12th?
Personally, yes.
Yes, personally, when the two of you were together.
Yes.
And in your first meeting with Mr. Simpson, he didn't share with you his life secrets about him having rheumatoid arthritis or things like that, did he?
Oh,
No.
And you're not surprised by that, are you, sir?
No, no.
You didn't share with him any maladies that you may have, even at your young age, did you?
No, I didn't.
You were just trying to get to that airport on time. Isn't that correct?
Yes.
All right. Now, sir, with regard to questions you were asked whether or not you were in a hurry, and you indicated to Ms. Clark at some point that you were, in fact, in a hurry, again, because you wanted to get Mr. Simpson to the airport on time. Isn't that correct?
Correct.
And you previously told us already that at some point you drove perhaps as fast as 75 or 80 so you could accomplish your goal, right?
Correct.
Which you did, right?
Yes.
And recall Ms. Clark asked you some questions about whether or not you were looking or paying attention to Mr. Simpson's body or his hands. Remember those questions?
Yes.
You would have remembered, would you have not, if Mr. Simpson had a Band-Aid, a large Band-Aid on this left knuckle here, would stand out. You'd remember that, wouldn't you?
If I saw it, yes.
Right. You never saw that night, did you?
No.
All right. Now, with regard to the time you were waiting and trying to get inside the Ashford gate, would I be correct in assuming that your attention at that time was you were concerned about trying to locate somebody inside the premises and reaching your client? Isn't that correct?
Yes.
In fact, it was so much so that you not only called your boss, but you also called your mother. Isn't that correct?
Correct.
During that time frame. And that pretty much was your focus. Isn't that right?
Yes.
And when you testified at the preliminary hearing as follows, counsel again at page 40. Yes, page 40, beginning at line 17, line 15. Actually, question, when you asked these questions and gave these answers to Ms. Clark, what gate did you leave from? Answer, the Rockingham gate. Question, and which way did you go on Rockingham as you exited the gate? Answer, I made a left. Question, did you look to see whether any cars were parked on the right side as you faced the driveway of Rockingham outside the residence? Your answer was, I didn't look to see. Question, you weren't looking at the parked cars? And your answer was, yeah. You weren't looking at parked cars that night because your focus was on something else. Isn't that correct?
Yes.
As you told us before, you can't be positive whether or not there was any parked cars parked there to the right of the gate when you came out of that gate. Isn't that correct?
Yes.
And when you testified at the grand jury in that connection, you were again trying to be as accurate and as factual as you could. Were you not?
Yes, I was.
Counsel, let's begin at page 270, about line 21. And let's go over to page 272, Line 14. Question. I'm sorry, grand jury. I'm reading it all. Recall being asked these series of questions by Ms. Clark on June 17th, 1994. Question. When you pulled out of the driveway of the suspect's house, what driveway exit did you use? Ashford or Rockingham? Answer, Rockingham. Question. When you pulled out of the Rockingham gate, were you able to see any car parked on the street next to that gate? Answer, there was a vehicle to my left. When I was exiting, I noticed I had to look around a vehicle. I never noticed what kind of vehicle it was. I didn't pay any attention to that. But there was a vehicle there. Question. You say a vehicle to your left. That would be the area I'm indicating with my pen. Answer, correct. Why don't you mark that? You said you noticed a vehicle down there. Answer, yes. Witness complies. Go ahead and have a seat. You exited out of the gate that feeds onto Rockingham. Is that right? Answer, yes. So you're on the left side of your car, right? Answer, yes. And you're going to make a left out of the gate. Answer, that's correct. So you're looking to your left for traffic, for oncoming traffic. Answer, yeah, both ways. Question, did you attempt to look very carefully to see whether cars were parked on the other side of the driveway? I presume that means to the right side. Answer, there were no cars. Well, she's right, and I can help read it the other way, but I'm
All right,
trying to
let's
make it
read the
clear.
transcript, counsel.
Did you attempt to look very carefully to see whether cars were parked on the other side of the driveway? Answer, there were no cars. Question, are you sure? Answer, I'm pretty sure. Question, did you make an effort to look and see if there were any cars there? Answer, I looked to the right to see if there were any cars coming down the street. While I'm asking you if you looked to, made an effort to see if there was a car parked. Answer, no. Is that a correct answer? At that
Yes.
time? All right. And question, there might have been a car parked there and you didn't see it. Answer, correct. And the reason why you don't know one way or the other is because you weren't focusing on any cars or paying any attention. Isn't that right?
That's
And basically your focus was to get Mr. OJ Simpson, try to get him to the airport on time. Isn't that correct?
that's correct.
And that's what you ended up doing, isn't it, sir?
Yes.
Now, have you ever heard the engine of a Ford Bronco?
What year?
Well, that's a good question. Let's see. Well, let's start with my question first. Have you ever heard the engine of any Ford Bronco?
Yes.
And what year was the Ford Bronco that you heard?
I've heard a lot of them.
Have you? Well,
Yeah.
Well,
Well,
so-
older cars some of the older Broncos seem to be a little bit louder
all right.
than the new ones.
All right. Let's see. What's the newest Ford Bronco that you've heard?
I think it was an 88.
An 88? And what's the oldest?
It have to be somewhere around a 70, 72.
A pretty old one, is that right?
Yeah.
All right. And how long ago was it that you heard the engine of the 88 Ford Bronco?
Oh, I don't remember that.
Sometime in your past?
Yes.
And would it be correct in assuming those engines can be loud on occasion, those cars?
Could be.
You didn't hear the engines in any cars or anything that sounded like a Ford Bronco that night, did you?
No.
Now, Ms. Clark asked you some questions about,
I mean, no, I mean, it probably had a 302 in it, and they're not that loud. I mean, they're not whisper quiet, but in the 80s, they were normal, and a lot of them had cherry packs on, but they're not that loud. They're not like, I don't even know where he went there. I don't even know why he went there.
this figure who was walking into the walkway there, the Rockingham residence. Is that correct?
Yes.
Remember that? And you recall that as you testified for us, the figure was walking towards the door when you first observed that figure, right?
Yes.
And you saw that figure for only a second or so. Isn't that correct?
Yes.
And you told us that the figure was attired in something dark, and it could have been a robe. You don't know what it was. Is that correct?
Overruled.
Could have been a robe. Is that correct?
Just seemed to be dark clothing. Could have been anything.
Yes. Could have been anything because you don't know. Is that right?
That's true.
You got just a fleeting glance. Isn't that right, sir?
Yes.
So you never had a chance to see the hem of a robe swirling around or anything of that nature, did you?
No.
And with regard to this time frame,
Donald, you were late too.
you shared with us that it was your belief that the time that you saw this figure to the time that you saw Mr. Simpson come down with the bag, which we now know as the Louis Vuitton bag, one of the defendant's exhibits, about 5 or 6 minutes have passed. Isn't that correct?
Thank you so much, Kelly. Thank you. Thank you.
Overruled.
And that's about 5 or 6 minutes. Isn't that correct?
Yes.
And that's your best estimate. Isn't that correct?
Yes.
And you've done that throughout your testimony here. Give us your honest and best estimate. Isn't that right, sir?
Yes.
And you've done that with regard to that 5 or 6 minute period of time, right?
Yes.
When you were shown People's 112 for identification, the foyer area of the Simpson residence there. Do you recall on that night whether or not there was ever a rug anywhere in that foyer area when you were in there, when you were inside there?
No.
You recall that you walked some 2 to 3 feet in yourself, but you don't remember seeing a rug or any kind, right?
No.
Is that right? Now, you never went out and looked, and you were asked some questions about looking in the play yard for golf balls. You never did that, did you?
No, I didn't.
Ken, you weren't there to look for golf balls? Well,
Overruled.
you didn't go around looking at Mr. Simpson's premises for any golf balls or anything, did you?
No.
You came there to do a job, and you tried to do that job. Is that right, sir?
That's correct.
Overruled.
You came there to pick him up, and you left
That's
as soon
correct.
as you could, right?
Yes.
You were asked some questions on redirect examination by Mr. Clark regarding the location of this smaller bag that was some 20 feet away from you. Recall that?
Yes.
As you think back in your mind's eye, if you think back in your mind's eye, can you tell us how far that second bag was away from the second car, if the second car was there?
Do you understand the question, sir?
Yes.
You may answer.
It seemed to be 3 to 5 feet behind the back bumper
Of which car?
of the second car.
In other words, so if we could put that diagram up, it would be behind where you believe the back bumper of the second car,
Yes.
not the Bentley. Is that right?
Yes.
I understand your testimony. Mr. Cato Kalin had placed the golf clubs in the back of the limousine at Rockingham. Is that right?
Yes.
And with regard to these golf clubs, now they're marked as one of our limits. $1063 for identification.
Yes,
May I approach, Your Honor?
you may.
It's your belief that as you lifted that the items that you lifted that night appear about the same way as
It's
that.
about to go, it looks like it's about to go over.
Oh. Stand there with it, man. It's your testimony that when you lifted this item on the night of June 12th, 1984.
Thank you,
it appeared about the
Donald.
same way,
I
right?
appreciate it.
That's
Thank you
correct.
so much.
And this morning, remember, I asked you some questions about this particular insignia of the Swiss Army brand limited. Would change your testimony, Bob, at all if I were to tell you that
Sustained.
I haven't said it yet, Your Honor.
The way it was phrased, I don't think it was appropriate.
All right, well, may I put you for a moment?
Sure.
With regard to this bag, this golf bag covered with a sheath of some kind, are you acquainted with custom-made golf bags? Seen those before?
Yes.
And
Overruled.
and are you aware that this is a custom-made golf bag? But may I finish? Are you aware that this is a custom?
Finish the question. Finish the question.
Are you aware that this is a custom-made golf bag by the Swiss
And-
Army Brands Limited?
Does this appear to you to be?
Okay, yes, Your Honor. Does this strike? Thank you, Your Honor.
Overruled.
Does this appear to you to be a custom-made golf bag by Swiss Army Brands Limited?
It appears to be.
Do you know, do you have any idea how many custom-made golf bags were made like that one before you there by Swiss Army Limited?
I have no idea.
Do you know whether or not these custom-made golf bags by Swiss Army Limited were only for special customers?
I don't know that either.
Do you know whether or not they were ever commercially sold?
No.
Now, you were asked a series of questions by Ms. Clark about what was in these various bags, and you have no knowledge at all of what was in the bags. Isn't that correct?
No, I don't.
Again, your job was to get the bags and the client to the airport. Is that right?
Overruled.
Yes.
Did you see the skycap who waited on you and Mr. Simpson that night, or was there a skycap who waited on you?
There was a few around. I saw him, but I wouldn't recognize him.
You didn't recognize him?
I mean,
I don't want my koalas to see a murder trial. I had to put him away.
I wouldn't recognize him now if I saw him.
If you saw whatever this individual was a male, I presume?
Yes.
And if you saw him again, you would not recognize him. Is that a fair statement?
Yes.
And with regard to your conversation with the detectives Tippett and Carr, when you became aware they were going to look in the back of the limousine on or about the 15th of June, where was the limousine at that time?
It was at Dale St. John's in his
That's where-
garage.
And that's where you had taken
made
it
them.
after you
You did.
dropped Mr. Simpson off that particular night?
Yes.
Do you know whether or not Swiss Army Brand Limited makes any other decal for golf, for specially made golf bag covers?
Do I? I don't know if they do or not.
right.
I've seen other labels.
But do you know whether or not they make any other decals for the specially made golf bags?
No.
Thank you very kindly, Mr. Barber.
Ms. Clark? Sure.
Mr. Park, during the time you spent with Mr. Simpson on the night of June the 12th, were you looking at his hands?
Oral. No, it was asked on
No.
recross.
No, I wasn't.
So if he'd been wearing a Band-Aid, would you have noticed it then?
No.
Did Mr. Simpson, excuse me, and when you were at the Rockingham location, sir, before you saw the person walking into the front entrance of the house at about between 10:54 and 10:55, had you been listening for Ford Broncos?
I wasn't listening for anything.
So could one have driven by either on Rockingham or Ashford without you noticing?
Oral.
Repeat it?
Could a Ford Bronco have driven by on either Rockingham or Ashford without you noticing?
Yes.
And did Mr. Simpson seem to have any trouble lifting that golf bag onto the luggage carrier or taking it out of the trunk?
Sustained. That's beyond the scope. Sustained. Sustained.
Can we approach, Your Honor, on the scope issue? Was gone into.
Okay.
She's not going to win this one, but she should. She should win this one. Whatever it is, it's
When Mr. Simpson picked up that golf bag out of the trunk of the limo and put it onto the luggage carrier, did he seem to have any difficulty in lifting it?
Oral.
Not that I noticed, no.
Thank you, sir. Nothing further.
Cochran.
When he lifted it up and placed it on this luggage cart or whatever, you weren't paying attention about whether you had difficulty or not, did you?
No.
Because you were thinking about it was now over, you were going to go home, isn't that right?
Yes.
no. I mean, if he had trouble lifting it, or if he was so arthritic that he couldn't lift it and he would ask someone else to lift it, he would have saw. He would have saw.
Oral.
It was 11:35 on Sunday night, and I presume you wanted to get home, didn't you?
Correct.
Objection beyond the scope.
Oral.
You went home after that, didn't you?
Yes, I did.
You'd like to go home now, would you?
Sure would.
You got it.
Ms. Clark.
Did you watch Mr. Simpson as he picked it up out of the trunk and put it on the luggage carrier, sir?
That's the answer.
Oral.
I'm sure I was watching him, but I didn't pay any attention to it.
You didn't see him grunt or groan, make any movements?
No.
Suggested the other story.
All right, well, the answer will stand. I think we finished this topic, though. All right. Mr. Park, thank you very much for coming in. I'm going to excuse you at this time. However, you are still subject to being called as a witness. Do you understand that, sir?
Yes, I do.
All right. Don't discuss your testimony with anybody except for your own attorney or the attorneys on the case.
Thank you very much.
All right. Next witness. All right. Judge Wong. All right. Thank you, counsel.
Raise your right hand, please. You do solemnly swear that the testimony you may give in the cause now pending before this court should be the truth, the whole truth, and nothing but the truth to help you God.
I do.
Please have a seat in the witness stand and state spell your first and last names for the record.
Sure.
Judge Wong, you are a retired Superior Court judge, sir?
That's correct.
And in connection with this case, you've been acting as a special master, is that right?
That is also correct.
Okay. And what is a special master, Judge?
A special master is a person who is appointed to carry out certain specific assignments.
And in this case, were you given an assignment by Judge Ito?
That is correct.
Okay. And were you given an assignment directing you to retrieve certain items on March 28, 1995?
That is correct.
And showing you, or rather directing your attention to the golf bag in front of you, Defendant's Exhibit 1063. Do you recognize this bag?
Yes,
On what date and at what time did you recover that bag?
I recovered the bag yesterday,
What time of the day, if you recall?
about 4 o'clock.
Okay. Who else was present?
Mr. Kardashian,
The gentleman standing here,
yes,
one of Mr. Simpson's lawyers, Robert Kardashian.
yes.
And from where, or from what location did you recover that bag?
This was in the garage at 360 North Rockingham.
Someone point that bag out to you?
Yes, Mr. Kardashian did.
You didn't search the garage, I take it.
Pardon?
You didn't search the garage?
No, I did not.
Okay, you didn't search any portion of the house?
No, that was
Judge-
not my assignment.
Your assignment was to go see Mr. Kardashian, who would point out certain items to you.
And I was to take possession of those items.
And showing you what has been marked Defendant 1062, a Louis Vuitton garment bag, sir.
Yes,
You recognize that bag?
yes, I recognize it.
You recovered that bag yesterday?
Yes,
From where, sir?
this was from the second story master bedroom. It was in a closet to the right of the vanity.
Okay. Was it on a shelf in the closet?
It was on top shelf.
And was that bag pointed out to you by Mr. Kardashian?
Yes,
Were there other Louis Vuitton bags similar
I
to
don't
that
know
one?
if there were Louis Vuittons, but there were several other bags of various sorts in the closet.
But that particular bag was pointed out to you by Mr. Kardashian?
Yes.
Gosh, I really hope Judge Ito tells Judge Wong to please let him finish his question before he starts talking. Court reporter can't take two people at once. Please let it happen, please.
At the defendant's house?
Yes, that's correct.
Hi, Hedwig.
Was there anything inside the bag when Mr. Kardashian pointed it out to you?
No, I did not open the bag. The bag is intact.
Okay. And you did not open the golf bag?
No, I did not.
When I went to Texas to see the judge the last time, the ticket that I had purchased, 0 carry-ons. You were not allowed to carry on anything. I was allowed to have my purse, just my purse. And I don't even think I could have purchased a spot even if I wanted to, because there were no spots left on the plane for any bags. So I stayed overnight in Texas. So I had to pack for an overnight. I had 2 dresses, one I was wearing, and one I had to pack everything in my purse. And I fit everything for an overnight in Texas in my purse.
So you delivered those bags to the court in the condition in which you found them, sir?
That's correct.
And showing you what has been marked defendant's
Nope, just my purse, my regular purse.
black bag. Recognize that bag, sir?
Yes, this is the garment bag that we recovered from the master bedroom.
At the defendant's house?
Yes,
And where was it? Where in the defendant's house was that bag?
this was in a closet to the left of the television in the defendant's master bedroom.
No one I was with down there would have understood how amazing that is. You guys do. And I packed everything in my little purse. My dress for the next day had a sweater.
Okay, and that was pointed out to you by Mr. Kardashian?
Yes,
And to go back to the golf clubs for a moment, did you recover those golf clubs from the defendant's house or from Mr. Kardashian's house?
No, the golf clubs, no, you're right. The golf clubs came from Mr. Kardashian's house
Okay. In Encino.
in Encino.
Okay. And they were in the garage.
Yes,
In Mr. Kardashian's garage?
yes.
Do you know how they came to end up in Mr. Kardashian's garage?
No,
And do you know the history or the chain of custody regarding any of these items?
no, I do not.
You don't know where they were prior to your recovery.
That's correct.
Thank you, sir.
Mr. Cochran.
Good afternoon, Judge Wong.
Good afternoon.
As a special master, you work along with Judge Ito to retrieve certain items of evidence. Is that correct?
That's correct.
And you've been a special master in this case for some time now, have you not?
Yes, since June, I believe.
June of 1994?
That's correct.
And you retrieved other items of evidence, isn't that
Yes.
correct? Well, I'd like to go
I'll
into,
just let that stand at this point.
okay, I'd like to ask him some questions, and I'd like to approach and ask, before I ask those questions.
Let's approach the sideboard. Thank you, Counsel. Mr. Cochran, do you have any further questions? for
Just a
Judge
few
Wong?
other questions, Your Honor. Thank you very kindly. Judge Wong, in this instance, you were requested to meet Mr. Robert Kardashian yesterday at about 3 o'clock to retrieve, at 3 o'clock in Mr. Simpson's home to retrieve certain items located there. Is that
That's
right?
correct.
All right. And by the way, with regard to the Louis Vuitton bag, did you notice whether or not there's any luggage tag on that bag?
Yes, there are some luggage tags.
And, this luggage tag on here apparently from American Airlines, is it not?
Yes, American Airlines, and the tag indicates Chicago O'Hare Airport,
And it has a flight number somewhere on, I presume.
668.
And was that luggage tag on that bag when it was pointed out to you in Mr. Simpson's closet?
Yes, it
yesterday?
was.
All right. And then you then brought that luggage in its present form to court this morning, as I understand it.
That's correct.
And the, we call it garment bag, the black garment bag on top thereof was also found in one of the Mr. Simpson's closets. Is that correct?
That is correct.
This dress I'm wearing, it goes down to my ankles. It's very, 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 very long. It goes the whole way down to the floor. This is what I had in my purse. I had everything inside of it and rolled up real tight. This is the dress that I wore down in Texas. I forgot about that.
And then the golf bag here that I'm now touching, the Swiss Army logo, so that we're clear for the record, that bag was also found in Mr. Kardashian's garage. Is that
Yes,
correct?
that was in Mr. Kardashian's garage.
And you accompanied him to that location. Is that correct?
That is correct.
And with regard to the that bag also, it has a particular flight number, does it not?
Yes, American Airline Flight 1103.
And does it show where 1103 flew into?
Los Angeles.
All right. And so these items are in the same condition they were in when you found them. Is that correct?
That is correct.
If I were to hold up this item here, this black bag here. I'm gonna hold up this black bag here. Did you make recovery of this also?
Pardon?
Did you make recovery of this bag?
No, I did not.
Certainly.
It's very expensive, JJ. Could we share a hotel room?
May I approach, Your Honor? Thank you very much, Judge Wong.
All right, Mr. Jordan, any further questions for Judge Wong?
Judge, the garment bag shows flight number.
The garment bag shows flight 668, American Airlines to Chicago O'Hare.
That's to Chicago, is that correct?
That is correct.
Not to Los Angeles.
That's what it says, Chicago.
Okay. And showing you the golf bag. What is the flight number on this bag?
American Airlines 1103, LAX.
So So the garment bag and the golf bag then show tags for different flights. Is that right?
That's correct.
You're aware that the murders occurred on June 12th, 1994?
Sustained.
Well, is there a date and time stamp on the garment bag?
The date is June 13 on the garment bag.
And is there a time as well on that tag?
23:32, which would be just a little before midnight.
On June 13th.
That's correct.
Is that military time?
That is military time,
11:32 p.m.
11:32.
Judge, do you see a date on the tag for the?
Golf bag bears the date.
You're welcome.
Time is
Just mull all over the evidence, guys. It's fine.
Oh 09/21, 13th of June.
So the golf bag then apparently was.
I'm going to go get more
9:21
coffee while they
a.m.
talk about bags.
That is correct.
Be good.
By the way, your retrieval of these bags or these items, that was made pursuant to a defense request. Is that right?
That was, my instructions were from Judge Ito.
Thank you, sir.
Regards, just one last question.
One last question.
Well, maybe two. Judge Wong, with regard to these items, so that we're clear, abundantly clear, these items were picked up by you here in Los Angeles, California, right?
That's correct.
Thank you.
Yesterday, that's correct.
Thank you, sir.
All right. Judge, thank you very much. You're excused, sir. And Mr. Doherty, can I get you to collect those items and give them back to Mrs. Robertson? Thank you. Certainly. Panel, people may call their next witness.
Thank you, Your Honor. People call Mr. James Williams.
All right, Mr. Williams, come forward. Face the clerk, please.
Raise your right hand, please. You do solemnly swear that the testimony you may give in the cause now pending before this court shall be the truth, the whole truth, and nothing but the truth, so help you God. Please have a seat in the witness stand and state and spell your first and last name for the record.
Says my first name,
And last name.
James Williams, James, Williams, Williams.
Thank you.
All right, good afternoon, Mr. Williams.
Good afternoon.
Ms. Clark.
Good afternoon, Mr. Williams.
Afternoon.
A little bit nervous?
Yeah.
All right. It won't be bad. Would you like
Is,
some of your own?
yeah, is the water fresh?
It's from someone else.
Can I have some water? I'm thirsty. The water out there is hot.
It's not hot, it's toxic.
Tastes like metal.
Yeah.
It tastes like metal.
But you're still alive.
Yeah.
All right, we'll get you some good water.
All right, Ms. Clark.
Sir, as of June the 12th, 1994, where were you employed?
At LAX at American Airlines, where I'm a SkyCap, contracted out from American, employed by Huntley.
Employed by,
Huntley
Huntley.
USA.
can you spell that, sir? Huntley?
Huntley, capital HUNTLEIGH.
And then you contracted out through them to work as a SkyCap for American Airlines?
Mm-hmm.
Was that yes?
Yes.
You have to say yes or no
Okay.
for the reporter. All
Okay.
right. And what were your duties as a SkyCap?
Check bags for passengers, passenger assistance, check bags on the curbside. Just passenger assistance.
And how long had you been working as a SkyCap as of June the 12th, 1994?
As a SkyCap, about a year and a half.
What were your work times back then?
At that time, I had a straight 7 o'clock shift. It was 7 in the evening to 2 in the morning.
And on the date of June the 12th, 1994, did you start work at 7 p.m.?
Yes, I did.
And were you still at work at about 11:30 p.m.?
Yes, I was.
Did someone approach you about 11:30 p.m. to ask you for help with some bags that you happen to recall?
Yes.
Can you please tell us what happened in that regard?
You want me to tell you what happened after?
Well, first tell me, do you recall a young Caucasian man coming up to you and asking you for help with bags?
Yes.
What happened after he asked you for help?
Well, he asked me for help, and I was helping somebody at the time. So I told him I'd be with him in a minute, and he went inside. He seemed a little hurried because he wanted to get the bags checked, I guess. And so he ran inside to go get a cart so he could get them himself. And then he went back to the limousine.
Did you
Yeah.
see him get a cart, sir?
I didn't see him get it, but I saw him with it after he came back out because I was helping somebody. So I didn't pay much attention to him after that.
And did you see where he took that cart to?
He took it to the limo.
You saw a limo?
Yes.
How far was that limo from your podium?
I'd have to say it was about 20 yards, 25 yards.
20,
It
25
It
yards?
was a good, about 25 yards.
And after you saw him take the luggage carrier over to the limo, what happened next?
Well, I just saw him take the luggage cart over there. I didn't really pay attention to him getting the bags out because I was helping someone. So, I just finished helping who I was helping. And then, I was almost finished with the person I was helping. And I saw him walking back up.
The same guy?
Yes.
And when he came walking back up, did he have a luggage carrier with him?
Yes, he had the,
Did
he
he
had
have?
the little cart with the bags on it.
And what bags were on that cart, sir?
He had a golf bag and 2 other bags. No, he had a golf bag and 1 other bag.
Can you describe the golf bag?
It was a dark colored golf bag. Dark colored golf bag. It was.
Could it have been, when you say dark color, does that include navy blue or black?
Yeah, like navy blue, black.
1063? Is it marked? Yeah, it is. Showing you what's been marked as defendant's 1063, sir. Can you tell us, please, if you recognize this particular bag, sir?
Yeah, that's a black golf bag. I mean, I didn't pay that. I mean, I didn't just analyze the bag and check. I just checked it.
You analyzed it, you just checked it?
Just checked it.
All right. So can you tell us whether or not that was one of the bags on the luggage carrier that the young man had?
Yeah.
James Williams is his name, and I can't find anything like it affected him in any way.
I could say that's one of the bags.
Pardon?
Yes. Yes, it could be the golf bag.
Could be.
Yes. I mean, like I said, I didn't memorize and look at the golf bag that closely.
And there was some other bag on top, on the luggage carrier as well, sir?
Yeah,
And can you describe that bag?
it was like well, I remember it was a hanging bag.
And by hanging bag, do you mean a garment bag?
Yeah, for hanging clothes if you don't want to get messed up.
Mm-hmm.
It folds over. But
It can be folded, but it can hang straight?
Yeah.
All right.
yes.
And do you recall what that looked like?
Um, Same with the golf bag. I mean, it was just a regular bag. I mean, I see so many. I mean, that's why I didn't pay a whole lot of attention to it. But I just know it was another bag there.
Do you remember whether it was one of those designer bags or not? That
No,
had
I
those
couldn't.
logos on it?
I couldn't tell you.
Okay. So who was pushing the luggage carrier, sir?
The Caucasian man.
And was there someone else with that young Caucasian man?
I didn't notice the other person at first. He was standing like out of my sight. When I first turned, I was facing the podium, helping the people I was helping. And then after I finished with them, I turned to my left and I asked him if he needed help. And then that was at that time that I noticed through my peripheral vision, I could see someone else standing there. And it was,
Could you see who that was?
yes,
Who was that?
Mr. Simpson.
Is that someone you see in court today, sir?
Yes,
Okay. Can you point him out?
Mr. Simpson.
Indicating the defendant.
Thank you.
Yeah, Mr. Simpson.
Okay. And was Mr. Simpson carrying anything when you saw him?
Yes, he had a bag.
What kind of bag?
It was like a little duffel bag.
A duffel bag?
Yeah.
And what color was it?
It was dark colored too, from what I remember. I mean, like I said, I didn't, pay specific attention to it.
Could you tell us, sir, how he was carrying that duffel bag, in his hand or on his shoulder?
When I saw him, it was on the shoulder.
On his shoulder?
Yeah.
All right. Now, did you personally check any of the bags for the young man or Mr. Simpson?
Yeah, I checked 2 bags,
What bags did you check?
the golf club and the hanging bag.
Now, when you check bags in, sir, do you create some paperwork or tag them in any way?
Well, you have to pull the tags from the computer, and they're automatic. They just come out when you pull them out, and you just put them on the bags.
Okay. Now, the tags that come out of that computer, sir, are they stamped with date and time?
Yes, they are. Matter of fact, yeah.
And when to your knowledge, sir, are tags placed on, excuse me, strike that. When you place the tags on the bags that you're checking, does it reflect the date and time at which you place those tags on the bag?
Yeah, it tells you that, the tag was pulled at this time on this day by this sky cap. It has a number. It has like the date, the time, and then, it has the code, my code that I have to use to get into the computer.
So that date and time shows when the bags were checked in?
Yes.
And does that occur as well when the bags return? Are they tagged with date and time when they come back from wherever they've been, or does that only occur when they're being checked in to board a flight?
When they're just when they're being checked in. I mean, either way, if you check your bags in Chicago and they pull it out of the computer, it's the date and time is on there.
I'm going to show you the exhibit that's been marked as defendant 1063. Ask you to look at the tag on this bag, sir. Do you recognize the tag that I'm showing you here? And for the record, Your Honor, it's a tag that says LAX AA 1103. Do you recognize that tag?
Yes, a regular American Airlines tag.
Is that the kind? Is that the kind of tag that you would put on the bag when you check it in?
Yes, it is.
And if you can tell us, sir, then the information on this tag, LAX at the top, what does that mean to you?
Los Angeles. That's where the bag is destined to go, to
Okay.
LA.
Oh, that's the destination?
Yeah, that's the destination, LA.
So then this tag would have been put on somewhere else because it was flying to LA.
Yeah, I can tell you why. Bag was checked in
Mr.
Chicago.
Williams, I need you to speak into the microphone.
Yes, this bag was checked in Chicago.
And you can tell that by,
Looking right here, ORD means Chicago.
mhm,
It's the code for Chicago at 9:21 on the
9:21,
13th of June.
9:21 in the morning, sir?
I, I couldn't tell you that. Yeah, because it's military time. So yes,
Okay. So this bag was checked in Chicago on June 13th at 9:21
yes,
in the morning.
yes,
And that means checked. And that means checked at the Chicago airport to go to LAX at that time.
yes. That's not the tag I pulled.
I'm sorry?
That's not the tag I pulled. I'm just
Right.
stating that.
Right, because you were working in LA.
Yeah.
Right. Now I'm showing you an item that's been previously marked as defendant's 1062. I'll show you, Your Honor, for the record, it's a tag that says ORDAA 668. Do you recognize that tag, sir?
Yes,
What is that?
American Airlines tag.
Mm-hmm. And is that like a tag that you would put on there?
Yes,
And what does that ORD at the top mean?
O'Hare, Chicago O'Hare Airport.
And that means that this bag was checked, and its destination was Chicago O'Hare.
Yes,
And can you tell us what time this bag was checked in? Sorry about that.
this bag was checked in at 11:32 on June 13th.
Checked in at 11:32 on June,
Yes.
11:32 p.m., sir,
Yes,
on June the 13th.
yes.
And it was checked in at what airport?
LAX.
And is that shown here as well?
Yes, right there.
Right there, where it says LAX.
And that's my code,
Oh, and where's your code, sir?
803.
H03?
H03.
H. That means that it was you?
Yeah.
So you checked this bag in at LAX on June the 13th at 11:32?
Yeah. Yeah. It was 12.
You didn't write that on there, did you, sir?
No, the computer prints it automatically.
Do you know whether those computers are accurate with respect to date or time?
Usually they are, but sometimes they have been known to have maybe be minutes off or something.
All right, then with respect to that garment bag, it would appear that you were the one that checked that in, sir?
Yes.
May I have a moment, Your Honor?
Yes.
All right, sir, now, the date I'm talking to you about with respect to checking in the bags for Mr. Simpson was June the 12th, correct?
Correct.
Are you surprised to see the date of June the 13th on that bag, on that garment bag?
Yes.
Can you explain how June the 13th got on that garment bag?
I have no idea. I couldn't tell you why it says June 13th.
Something with a computer.
Yeah, because I don't punch in the date. If the person is in the computer, it comes out automatically.
You don't have anything to do with setting the date on the computer?
I don't do that.
Okay. Now, did you ask the defendant where he was destined for before you punched out the tags?
Yes.
And did he tell you?
Yes.
And where was that?
Chicago.
And did he make any inquiry of you as to whether or not the bags would make it onto the plane?
He asked me if they would make. He pretty much asked me, yeah, if they would make it.
And what did you say?
I told him, yeah.
Did you give him some paperwork or something with respect to the bags that you checked?
Yeah, I gave him his claim checks for the bags.
And about what time was it when you did that, sir?
About 11:30.
Now, you indicated that he was carrying a dark duffel bag,
Yes.
showing you what's been marked previously as defendant's 1064. See this bag, sir?
Mm-hmm.
Is that yes?
Yes. I'm
Can
sorry.
you tell us? It's okay. Can you tell us if this is this looks like the bag you saw him carrying that night?
Yes.
Can you tell us if this was the bag he was carrying that night?
I couldn't tell you if it was the bag.
Looks like.
Looks like it.
Could you tell us if it appeared to be full or empty?
It has something in it. I'm not sure what, but I mean, it wasn't weighing him down or anything like that.
He had that on his shoulder.
Yes.
Did he check that bag in with you?
No,
What did he do with that bag?
he kept it with him.
Is there a trash can anywhere near your stand where you work?
Yes, just to the left of it.
The left of it as you face it?
If I'm facing the podium's here, the keyboard and everything, screen is here, and I say right over here is a trash can.
Okay, so if you're working at your podium, it would have been to your left.
Yeah, left and a little behind me.
A little behind you?
Yeah, a little behind me, not far.
Now, when you saw the defendant, sir, what was he wearing?
What I remember, it was a denim outfit. It was like some jeans, but jeans, light shirt, a light colored shirt.
Okay. Could it have been a denim type, light denim shirt?
Yes.
Light colored denim shirt?
And
Was that
denim
yes?
shirt. Yes. Keep forgetting.
How many bags did the defendant have, sir?
Just the 3.
The 2 you checked and the 1 he carried?
Yes.
Did you see any other bags with him?
No.
Did the defendant give you a tip?
Yes.
What money did he give you?
He gave me a 20, and I gave him back 2 5s.
He gave you a $20 bill?
Yes.
You gave him back 2 $5 bills?
Yes.
Is that the only time you've checked Mr. Simpson in for a flight?
Yeah, because I wasn't a sky cap the other times I'd seen him.
All right. Did you have a conversation with anyone the day after these events that we've just discussed on June the 12th?
Yes.
Was that a friend of yours?
Another sky cap.
And after you had that conversation with your friend, what did that cause you to do with respect to your memory of the events of checking Mr. Simpson in on the night of June the 12th?
Try to recollect what happened that night.
And did that cause you to reflect on everything that had happened, the number of bags checked and everything you saw?
Yeah, pretty much, yes.
So you only saw one black duffel bag, is that right?
Yeah, that's all I saw, yes. Aside from the other 2 bags.
The 2 you checked?
Mm-hmm.
Is that yes?
Yes. I
Those
keep
2 that you
forgetting.
checked- I know. The 2 that you checked, though, neither one of them were duffel bags.
No.
The only duffel bag you saw was the one he carried in over his shoulder?
You can ask the question. Go ahead.
Oh, yeah, that's the only one I paid attention to. I mean,
Mr. Douglas?
Hi, Bill. Bill's here. I'm very famous, guys.
good
Bill's
afternoon.
Bill just drops by. Yep.
Mr. Williams, how long, sir, had you been working as a skycap as of June the 12th of 1994?
About a year and a half.
For about a year and a half?
Yes.
And, sir, typically, what would be the number of passengers that you would check baggage for in a given, let's say, a given hour?
That depends on the day, because some days are busier than other days.
What would be your average if you were to estimate how many customers you tend to handle in a typical hour?
In a typical hour, maybe 15, 20, maybe.
15 to 20 per hour.
Yeah, you know.
And frequently, each of these passengers, these 15 or 20 per hour, will often have more than one bag. True?
Yeah.
So it wouldn't be unusual for you to see dozens of bags in any given hour, considering all the passengers that you're handling. True?
True. Yes.
Now, there came a time on a Sunday evening, you say, when
Josh, that's a secret. So that Florida guy, all those things you hear about that Florida guy, they're all Bill. All of them. Everyone.
this fella came up to you asking about checking in some baggage, correct?
Correct.
And later you realized that there was a passenger with this person who was Mr. Simpson, true?
Excuse me, repeat the question.
You later realized that this person that had come to you was handling bags for Mr. Simpson.
Yes.
Didn't you? And Mr. Simpson came to you on a Sunday evening, didn't he?
Yes.
He didn't come the next day on Monday evening as well, did he?
No.
And part of the process of your checking in the baggage was to verify Mr. Simpson's flight schedule on the computer there, correct?
Correct.
And you were able to verify that Mr. Simpson was in fact booked on a flight that evening, didn't you?
Yes.
Now, was he booked on a flight for real? Or was he Rosa Lopez booked on a flight? Remember how Rosa Lopez was booked, but then wasn't really booked, but then sort of almost booked, but then not even really reserved.
Now, there's certain information that you put into the computer before one of these claim checks are printed out, correct?
Yes.
Part of the information that you put in would be the destination of the passenger.
Yeah, I can tell you exactly what the first thing you have to put in is how many bags are checked, what's the flight number, final destination, name of the passenger, and how many people are in the party.
Okay. And what is your practice, sir, when there is an old tag on the bag that you are going to check in? Is it your practice to take off the old tags first?
Yeah, either take it off or scribble up, mark over it so it doesn't interfere with the tag.
That's so that the baggage handlers will not confuse one destination from an old tag,
Yeah.
as opposed to the current destination, correct?
Mhm.
Now, every bag that is checked in has to have a luggage tag placed on it, doesn't it?
Yeah.
And when there is a bag that someone is taking on the airplane with them, there's no need to check that bag in necessarily, correct?
Correct. If they're taking it on, you don't check it in.
So that if somebody is carrying a bag, let's say that someone is carrying a bag to Los Angeles from Chicago, that they had checked in Los Angeles to Chicago, but they carried that bag on the airplane with them back from Chicago. there wouldn't be an LAX tag on that particular bag, would there?
You're saying he, okay, he checked it in LA.
Let's assume, for example, let's take the garment bag, which would be exhibit 1062.
Okay.
And if this tag has certain information, this means that this piece of luggage was checked in from Los Angeles to Chicago, correct?
Correct.
And then it was placed on a conveyor belt to go to the airplane, correct?
Correct.
And if the person who owned this bag brought it back from Chicago on the airplane with him, it would still have the ORD tag on it, wouldn't it?
Yeah, unless he took it off, it'll stay on there.
Okay. And if, for example, that same person was bringing back not only the bag that he's carrying on, but another bag that they're checking in Chicago to come to Los Angeles, it would be the practice to take off that old tag, would it not?
Yeah, you should take the old tag off because you don't want them to.
So that you cannot tell whether or not this golf club bag was checked in at LAX to Chicago because you don't have that tag on there, correct?
Yeah.
But you can tell that this bag was checked in at Chicago to come back to Los Angeles on June 13th. True?
Yes.
All right, guys, I'll be back in a few minutes. Be good, please.
Now, you talked something about there being a trash can somewhere near the area where you're working.
Yes.
And you would have occasion, would you not, to look into that trash can to see, to throw things away, wouldn't you?
Well, I just use it to throw things away because the way the trash can is designed, you just throw it in the front and it just goes down. There's like a cover over it.
And you never heard any information about there being any luggage recovered from any trash cans near your area, did you?
No, not to my knowledge. I never heard anything about that.
Now, you said that when you saw Mr. Simpson on June the 12th, that he was wearing a jean type shirt, wasn't he?
Yes.
And that shirt was not tucked into his pants, was it?
No.
And you recall that he had a white shirt on underneath that jean type shirt? Do you recall that?
No, I just remember a light colored shirt.
Okay. Do you recall ever seeing him carrying an overcoat that evening?
I can't recall.
You don't recall that?
No, can't recall.
Now, there came a time, as you said, that Mr. Simpson gave you a tip for your services, did he not? Did he not?
Yes.
And he gave you a $20 bill.
Yes, he did.
And you gave him back as change 2 5s. Is that correct?
Yes.
Was that all the change that you then had in your possession? Do you recall?
I mean, I had other money on me, but I mean, I just, gave him 2 5s. I didn't want to count out singles.
And as he was walking away, did you have occasion to stare at him when he's walking away? Or were you handling other work?
No, I was just trying to get his bags on for him. And so the way you go is there's the escalator, and then behind the escalator, there's a belt for oversized items like golf clubs and stuff. So, but realizing he was running a little, behind schedule, I just took him down the back way and walked him out half to the plane.
So after he gave you the tip, you then tried to rush to put the bags on that special belt for him.
Yes.
And you didn't focus your attention on him walking away from you going to the airplane.
I just, figured he went up to the plane because he had to.
So you really didn't have a chance to see what, if anything, he was carrying in his hand while you were putting the golf bag onto that special belt, did you?
Aside from the small little duffel bag.
Thank you very much. One moment, please.
Mrs. Clark, can you redirect? Certainly.
Is there anybody need more water? I'm just thirsty.
Mrs. Robertson?
Yeah, maybe approach.
Sure. We'll try to finish you this afternoon, Mr. Williams.
Okay.
Thank you.
Beats that stuff outside, really.
I know, don't drink that stuff outside. I know.
Man, it
You have
got
a skull
cold
and
and then it got
crossbones
hot.
over that. Yeah,
Just did a load of laundry in that water.
All
I
right,
know.
let's go. Ms. Clark.
If I may, Your Honor, I'd like to mark a series of photographs.
Starting with People's 150.
Thank you, Your Honor. People's 150 will be the photograph with the number 10 at the lower right-hand corner. 151 with the number 11 in the lower right-hand corner. 152 with the number 12 in the lower right-hand corner. 153 with the number 02 in the lower right-hand corner. And number 154 with the number 15 in the lower right-hand corner. And number 155 with the number 14
All right, so noted.
in the lower right-hand corner. Thank you.
Proceed.
All right, Mr. Williams, I just want to show you these pictures and ask you, you can tell us whether these pictures accurately depict the podium you worked at American Airlines, and the location of the trash can in relationship to that podium on the date of June the 12th, 1994. Okay?
Okay.
And for the record, I'm showing him the photographs I have just now marked as 150 through 155.
Hey, there's Kevin.
All right, now you've just seen 150 through 153, is that correct, sir?
Yes.
Okay, is that the way your work area looked at American Airlines on the date of June the 12th, 1994?
Yeah, it was darker, but yeah, that's it.
Because it was at night.
Yes.
And you described a trash can to your left and a little bit behind you where you work. Do you see it in that position in these photographs?
Yes.
And is
I
that the position it was in on June the 12th, 1994?
Yeah.
Showing you now people's 154 and 155. Do these photographs accurately depict the trash can that is shown in the photographs that have been marked people's 150 through 153?
Yeah, that's the trash can.
And that's the way it looked on June the 12th, 1994 as well?
Yeah, that's the same way it looked.
Can you tell us, sir, if you know, how often do you strike that? Do you see a plastic insert in that trash can
Yes,
that's
I did.
depicted in all those photographs?
Yeah, the trash bag.
Right.
Uh-huh.
Do you know how often they change those plastic inserts?
No, I couldn't tell you. I see them change them. I don't know how often they do it. They just change them.
You just know that they do.
Mm-hmm.
Okay.
Mr. Douglas, issues on this?
Mr. Williams, there is a lost and found section at the airport, is there not?
Yes, there is.
So if luggage is left behind or lost, there's a location where it can all be taken, true?
Yes.
And Mr. Williams, you don't recall ever seeing Mr. Simpson anywhere near that trash can on June the 12th, do you, sir?
Yes, he was standing near the trash can.
Did you see him do anything with the trash can?
No, I didn't see him do anything with the trash can.
When Mr. Simpson was standing near the trash can, sir, did you happen to see whether he had any item of luggage or that black duffel bag on top of the trash can?
No, I didn't pay that much attention to see if he, where the bag was. It was on his arm.
Was your back to Mr. Simpson when he was standing near the trash can?
When he first came up, yes, I didn't even notice it was Mr. Simpson until I turned and asked the limo driver if he needed, if he wanted to check the baggage.
And when you took the baggage from the luggage carrier to put it onto your luggage carrier, onto your conveyor belt, would you be turning towards the trash can or away from it to do that?
I'd have to turn towards it.
Okay, and you have pictures. Can you show us in the photograph, sir? Where is the conveyor belt that you would be putting the luggage on?
Which
Mm.
photograph you?
I'm sorry, I'm showing the witness people's 150.
I'd have to go in the door, and over here towards this way, there's the escalator, and then right behind the escalator, there's the big belt, and then there's some doorways that go out to the ramp. I just took the bags down there.
So would you carry them in by hand or would you put them on some kind of a cart?
Usually I put them on a cart, but in that situation, I just carried them in by hand.
Did you in this case carry them in by hand?
Yeah, they weren't that heavy.
So did you carry them in by hand before or after Mr. Simpson left your podium?
It probably would have to be. It was after he left. He was walking away, and I just grabbed the bags.
And walked them inside?
Yeah.
Do you know if those trash cans are emptied every night, sir?
Yes, they are. They're empty sometimes. Yeah, they are emptied every night because when the trash truck comes around, it kicks out so many fumes. It's pathetic. Kills us every night. Get electric vehicles.
So that I'm clear, Mr. Williams, Mr. Simpson left the trash can area before you went around the corner to put the bags away.
Yeah, he's.
All right, Ms. Clark, do you want to hand the photographs to the jurors and allow them to pass it through so they can look at it?
What's that, John?
Asking Ms. Clark if she wants to hand these photographs to the jurors.
In view of
Sure. All right, thank you, Counsel. Mr. Douglas, you had two more questions?
Mr. Williams, just so that we're clear, the trash bags that go into the trash can that are shown in those exhibits are clear trash bags, are they not?
Yes.
And the location where that trash can is directly next to where you are standing checking in the bags, is it not?
Objection to state testimony.
Well, I think
Picture speaks for itself, Your Honor.
sustain.
That is the trash can directly next to the station where you're standing?
Yeah, same spot in the pictures, directly next to it and a little back.
So when people are standing and dealing with you, they are naturally standing next to the trash can?
Well, objection. He did something outstanding.
Overruled.
Speculation.
Overruled. The photographs will speak for themselves.
Yeah, they stand anywhere. They can stand in front of it.
Nothing.
All right.
Your Honor.
Nope. Not at this point. Do you want to ask another question?
No, I just want to show the pictures.
No, we had an agreement that I was not aware of. All right. Ladies and gentlemen, at this time, we're going to take our recess for the afternoon, and I take it neither side has any further questions for Mr. Williams. As far as the jury is concerned, we'll stay in a recess until 9 a.m. tomorrow morning. All right, we'll take a 10-minute recess, and then I'll see counsel on the other evidentiary matters.
Obviously, we have the defendant's proposed set of objections in the DNA issues. However, a matter of some importance before collection witnesses testify is the letter that we sent this morning concerning what we believe are discovery abuses and recent matters that were turned over to the defense by the prosecution that we think is a clear discovery abuse and for which there ought to be sanctions and remedies. So the issue is, we think that's a serious matter that has to be resolved before the witnesses testify. Then there's the stipulation, proposed stipulation by the prosecution, and then there are the boards. So those are all the matters that I think we have to cover, and I know you have limited time, so tell us what you want.
All right, well, let's do the motion let's start on the motion that was scheduled for this afternoon. The notice of objections to testimony concerning DNA evidence.
Maybe I ought to make one point about the discovery sanction. We sent a number of matters to the court in terms of the materials, but one that I think the court really has to look at is that we were provided with a videotape that we had been asking for a long time that was taken on June 13th at Rockingham. The way we knew about this a long time ago is that on that videotape that I think the court has of all the different clips we've seen from the services, there was a gentleman from the district attorney's office, or we thought, or police department, we didn't know where, taking a videotape. We just received a videotape from the prosecution of in panning the grounds and then an interior search or walkthrough of Mr. Simpson's residence at Rockingham. It's highly material and something that should have been turned over at the suppression hearings because it's relevant to those issues, would have been developed there in terms of search witnesses, in terms of their testimony. And there are a number of things that are perfectly apparent about it. Number one, there are things out all over in very important places. matters
Well,
of,
Mr. Scheck, forgive me for interrupting
Yeah.
you, but the issue before us today is your specific motion regarding Kelly
yes.
issues.
I understand. All that I'm saying is before the prosecution's next witnesses, the collection witnesses, Mazzola and Fung, testify, and people testify as to the
All right.
collection of evidence at Rockingham.
Well, I have on my desk what appears to be a fax letter to the court
That's right.
that mentions something about discovery sanctions, but in case you haven't noticed, I've been in session all day.
Oh, no, I understand that. That's why I'm bringing this one to your attention, because I
Right.
know you want to hear about it. Because what we're going to ask you to do is take a
No, the
look at
point
the
I'm
tape.
making is I don't want to hear about it right now.
Okay. Bottom line is, we think it requires a hearing before these, outside the presence of the jury, before the witnesses testify.
Okay.
That's why I want you to know that.
All right. Let's address the motion that you have on calendar for this afternoon.
My pleasure, Your Honor. What I would like to do first is a general introduction, and then explain what I'll address, and then defer to other counsel about the other issues. The first
What's your
point,
time estimate for our entire argument on this on your side?
30 minutes.
All right, proceed.
If I understand the prosecution's position correctly, what they're claiming is by withdrawing our initial Kelly Fry motion, we waived the right to contest whether or not correct scientific procedures were used in any of the DNA tests performed in the past or performed since the trial began, and tests that are still being performed as we speak. Whether correct scientific procedures were used, whether controls failed in the course of doing these tests, which are so material that they would invalidate the scientific merits of the tests, whether these tests were performed very, very badly, such that they should not come into evidence. They say we have waived our right to contest that under the third prong of Kelly Fry as an issue under 403 of the California Code or 405. They also claim that by withdrawing our Kelly Fry motion, we have waived our right to challenge under 352 the way DNA evidence is presented to the jury, particularly with respect to whether or not the statistical evidence is presented in a fashion that is misleading, unduly prejudicial, and should not be admitted under relevant case law. They indeed continue to insist that by withdrawing our motion, we cannot make objections under certain case law, People versus Sella, People versus Collins, that we cite in our papers. They claim that by withdrawing our motion, we have waived our right to cross-examine scientific witnesses from the prosecution about disputes within the scientific community concerning the reliability of the tests that they are going to offer to this jury. That we cannot talk about opinions of other leading scientists that would be generally relied upon by experts in the field, who are prominent scientists that were published in scientific journals, that we couldn't rely upon, for example, documents like the NRC report, or the fact that there's an NRC panel from the National Academy of Sciences, considering many of the criticisms that we've raised here, that they convene another panel. They're saying that we can't go into anything with respect to those disputes in the scientific community because we withdrew our motion. They say that we cannot offer testimony with respect to testing procedures such as mitochondrial DNA because we withdrew our motion. When in fact, during opening statement, Ms. Clark referred to procedures that are done to identify the bodies that were found overseas of soldiers. In fact, one of the techniques that is used, in fact, the primary technique, as I understand it, that is used is mitochondrial DNA testing by one of the proposed prosecution witnesses, Major Victor Whedon. They say by withdrawing a motion, we can't offer testimony on that. Their position is that on our direct case, we do not have the right to present evidence again through our witnesses under appropriate sections of the California Evidence Code. I believe it's 801, concerning opinions of other scientists and their concerns, published and otherwise, about forensic DNA testing that are the kind that are relied upon reasonably by experts in the field. What would ordinarily come in as proper basis for an expert testimony, they say, we can't do that now because we withdrew this Kelly Fry motion before. They have also made a motion in limine in which they, in effect, they say under 406, we can't attack the weight of the evidence and its reliability in this way because we withdrew our motion. They then propose this motion in limine where they say that we should be restricted in our cross-examination of prosecution witnesses about the views of Dr. Carey Mullis, the winner of the Nobel Prize in chemistry for the invention of the PCR technique, concerning his views on the application of PCR to forensics, such as was done in this case. And they concede in their papers that Dr. Mullis has testified on these matters. They have these transcripts, that their experts have looked at these transcripts and considered his views. They were before the court before. But they say that because we withdrew our motion, we can't cross-examine them about those. And they indeed go further and say that we can't cross-examine their witnesses about Dr. Mullis's views because his opinions have no value within the views they claim of their experts, although it's not in any way ever said that they're experts. There's no affidavits for any experts, or there's none named, because these experts believe that Dr. Mullis's lifestyle, Dr. Mullis's views on matters that are completely unrelated to this litigation, having to do with the etiology of AIDS and the HIV virus, are matters which discredit him.
Interesting theory.
I thought it was, we have problems with that because they say on that basis we can't raise his views with other witnesses, notwithstanding his winning the Nobel Prize about this technology. But what concerns us a great deal, Your Honor, is that we're about to enter the technical phase of the case. And you have issued an order to us, us lawyers, about how these matters should be litigated. And I pledge to you that we want to litigate these matters on the merits. In a highly professional fashion, try to conduct myself in this fashion throughout these proceedings. In a difficult subject matter that's turgid and gives everybody headaches, I understand it. But we have great concerns. This case on national television, it's broadcast around the world. People are reluctant to come in as witnesses, lay people. You know, it applies to scientists too. And when motions are filed where personal attacks of this kind that I think don't even merit serious consideration, what it does is it serves notice to everybody. If you want to come in here and talk about science, if you want to talk about real issues, well, you better be prepared to be put under a microscope and have your entire character subject to attack. And we think that's very unfair. We think that's intimidating to scientists. We think that's not the way this should be conducted, and we object to it. Now, what I propose to do, Your Honor, is at this point go through the objections that we made, our notice of objections, and deal with the prosecution's response to that. And then I'm going to defer to Professor Thompson to address the motion in limine issue. And then if we have time, we could move on to the stipulation which Mr. Blazer would discuss, and then the demonstration boards which Mr. Neufeld would discuss. The first point I'd like to make about our notice of objections is that we tried to design this in such a way to indicate to the court what issues we think you have to decide before the witnesses testify, what issues we think can only be decided after you hear expert testimony from both sides. And what I'd first like to discuss is the prosecution's contention that by withdrawing the DNA motion when we did, that we have explicitly given a blanket waiver to all the various legal challenges that we've given notice we want to pursue. And the matters that I want to discuss first are the prong 3, 352, 350 Collins Sella challenges. And Judge, I'm sure you'll appreciate it. Yes, we have done a chart that I would offer to the court. Can I just walk over? Okay. That essentially diagrams our brief and our various objections.
Very similar then to my chart diagramming the
Well, I don't know.
and the arguments.
The one you wouldn't
And
give
the
me the
case
other
law.
day, and the one that has the tentative rulings on it. I hope it's similar. Yeah, here. Okay. Now, the first point that the prosecution makes is that they say the day that we withdrew our motion, we explicitly waived all legal challenges, including the prong 3 challenges and all the ones that I've listed on this chart as grounds for objection that go beyond the first prong of Kelly Fry. And then they cite two sections of the record. And I'm sure the court remembers it, and the court reporter remembers it. But at the moment that this was done, there actually was, I heard, and I know we corrected it, a small error in the record or on the live notes, and that Mr. Simpson did not use the word waiver, he used the word motion. But that's not really the point. The point was that at the time that this was done, inconsistent with what the prosecution put in its brief, it was absolutely clear that Mr. Simpson was discussing, and we had proffered to the court, our withdrawal motion, which had very specific grounds as to what we withdrew and why we withdrew it. And that's what he was referring to. And then the court acknowledges this on page 10281 and says that you indicate that it was your understanding that Mr. Simpson was referring to the document that had been drafted, the withdrawal motion. And it's also clear from the record that we had discussed with Mr. Simpson the prosecution's proposed questions, and obviously they had their view at that time as to the significance of the withdrawal. But that's nothing that we explicitly acknowledged or believed to be true, and I'm sure the court realized at that time, I think you even indicated it, that one day we would visit the question of grounds for objections beyond prong 1, certainly with respect to the testing that had been done up to that point. So the prosecution's position that we explicitly waived in a blanket fashion all these challenges, I think has no merit and is backed up by the record. We should also note the factors, I won't repeat them because the court remembers them well, that went into that withdrawal motion, and that we wanted to raise prong 1 challenges. And we think by withdrawing the motion when we did, what we waived was we waived our right to attack outside the presence of the jury all DNA test results that had been done up to that point that we had received results from. That's what we think we waived. We asked the court in December to consider a procedure whereby we could litigate the prong 1 issues during the course of trial, having the prosecution present its DNA witnesses in exactly the fashion that they ordinarily would. Any witness that they felt they needed for foundation could be taken outside the presence of the jury, work on a Saturday or on a down day, whatever else, and that we would present witnesses. And then at the end of the trial, the court could consider striking testimony and give instructions to the jury, and we would waive the prejudice of having that bell rung and then unrung if we prevailed on any of those claims. The court declined our proposal at that time, indicating that you didn't feel we were sufficiently concrete about it and stating other reasons, and you just declined to do it. But we think we waived just at that point the right to do prong 1 challenges outside the presence of the jury, and we didn't waive any of the challenges that we've outlined here. So that was their first argument, waiver, blanket waiver, explicit waiver, which I don't think is supported by the record and our withdrawal motion. The second argument now is that that the prosecution officers is that they say under California law that you must do prong 3 challenges, 352 challenges, challenges that are we think governed by Barney Wallace and Pizarro, the Collins challenges, this notion of independence, People versus Sella, this notion of quantifying all the relevant variables accurately, that all those have to be done pre-trial through a Kelly Fry hearing, and they cannot be done during the course of trial by making objections. When we actually get the results and we see how the tests are performed. We don't think that that's correct. We don't think there's any basis in the law for that. And in fact, the prosecution seems to be going further. They seem to be taking the position that they are free, because of our withdrawal of the motion, to present any DNA evidence in any form, literally scientific garbage if they want, to the jury, without any limitations by the court or any right by the defense to object to foundations. We don't think that that makes any sense, and we don't think that's the law. It's very revealing to us that the prosecution in its papers does not even bother to make a point-by-point response to our various objections. They just say blanket waiver, and you either do it in a Kelly Fry hearing before the jury, or you can't waive these third-prong challenges, these 352 challenges, and the other challenges. We don't think that makes any sense. Now, in terms of these objections, what we would propose to the court is that there's only really 2 of them, maybe 3 of them, that have to be resolved before the witnesses testify. And those are, what I would say in our list is, number 1, presenting DNA evidence to the jury without statistics, and number 2, suggestions that DNA tests provide unique identification. A related issue, I think, is the second to last entry in our chart, the prosecutor's fallacy. But let me just address this first point, because I think it's an absolutely essential one. And it's one that highlights the way prosecution is proceeding here, that I think has been unfair and abusive in terms of way DNA evidence ought to be presented, and a matter that I think is of extraordinary consequence in terms of how this kind of evidence is going to be presented to juries from this point forward, not just in this courtroom, I think, but across the country, indeed across the world. What is DNA evidence and what isn't it? What is its real significance? How can courts structure the presentation of this evidence so that juries are not misled and they take it in the proper context for exactly what it's worth and what it's not worth? This is a very vexing question. This is one the National Academy of Sciences has opined on. As you saw from the papers we submitted, it's one that they're still struggling with, and it's also an
Damn, I had my mute on the whole time. Okay, let's try this again. Thank you so much. I appreciate it. I really, really do. I actually got my master's and my bachelor's from Western Governors University in Salt Lake City, Utah. Yep, I didn't go there. It was online. I was never been to Utah. I didn't go to graduation or anything. But yeah, that's where I got my degrees.
issue that all the legal and scientific commentators are commenting on. This isn't simple, but I think that there are certain points that have already been established in the case law of this state and other jurisdictions and within the scientific community that people take as clearly appropriate. And so we urge the court to think about this very carefully. This is the argument. Number 1, I think it's absolutely clear from Barney, and I cite Barney, Wallace, and Pizarro because at this point, I think that's all we can cite. The recent actions of the California Supreme Court in taking Venegas and putting a grant and hold on Soto, on Wilds, which was a different position than we were in when we began this trial, makes that the governing precedent. But under any precedent, DNA evidence is statistical. And you should not be able to present this evidence without statistics. Now, the prosecution has already done that in the opening statement, where Ms. Clark went on saying, here's a bloodstain match. Here's a bloodstain match. Then, in the examination of Detective Van Adder, in the course of a discovery violation, and I think the record's clear in a way that I think was purposeful, she elicited from him the testimony, oh, there were scrapings taken from under Nicole Brown Simpson's fingernails, and DNA tests were done, and the conclusion was that is her blood. Now, that's not what DNA tests show. They give you results which have gene frequencies. And that's what they show. They say this is the gene frequency of the profile. And nobody would
Actually, Barry, that is exactly what they show.
suggest that we're at a point now where those tests in particular, those PCR-based tests, could ever reach the conclusion that would satisfy any scientist that's her blood. Now, the law is clear in Barney that you cannot present this evidence without presenting statistics. You can't say it's just a match and not present statistics. But that's precisely what the prosecution has done so far in this proceeding. And it's not like they don't know what they're doing, Your Honor. They have all the people here in California that have been from the very beginning trying to engineer the admission of this evidence in favor of the prosecution, the proponents of it, and they know the law. And what's very interesting is that Ms. Clark, in an article by one of our brethren, Professor Richard Lempert, that we've cited, actually takes to task Ms. Clark's arguments in another case where she argued DNA evidence, and she did the very same thing. And that's noted in our papers. Now, that's unfairly prejudicial. So what are we proposing? What we're proposing is that as I think is the law, the evidence has to be presented in the form of statistics gene frequencies. But that's not all. If you agree with us, and you can see that that must be the way it's done because that is the law, then we deal with another question, and that is, what kind of preliminary instruction will this court give to the jury about these statistics? This, we think, is the most important point if you go with us the next step. And that is make them put it in the form of statistics. Because what the jury ought to be instructed is that what they're about to hear are statistical estimates about gene frequencies. And that they should be instructed that those gene frequency estimates do not represent the false positive error rates of the laboratory. They do not represent a probability about sample handling mistakes within a laboratory. They do not represent probabilities about false matches arising from cross-contamination in the collection of samples. And they do not represent probabilities as to whether or not evidence was tampered with. And they do not represent probabilities of guilt. And I think that the jury has to be instructed on exactly what it is and what it isn't. And we would, if you agree with us that it must be statistical, then we will present to you a preliminary instruction on this point that we think is essential to give the jury guidance about what they're going to hear, what it means, and what it doesn't mean. And these are issues that we raised in our initial briefs and people are writing about. There's an article that I would call to your attention that has just been published in Jurimetrics that was initially cited in our papers in its unpublished form by Dr. Jay Kohler concerning errors and exaggerations in the presentation of DNA evidence. And the research that Dr. Kohler has done and others in this field is that if you present, he did a study where you they did a mock case, and the jury of college students essentially was presented DNA evidence about a gene frequency of 1 in a billion. And then they were asked, given the evidence they saw, would they vote guilty or innocent? Then they were given the 1 in a billion gene frequency statistic, and they were also given a false positive error rate, something on the order of 1 in 200. And the jury reached exactly the same conclusion when they had both statistics, as opposed to just having the 1 in a billion statistics alone. In other words, it didn't affect it at all. On the other hand, if you gave them the statistics of just the false positive error rate, they would reach completely different verdict. There was a significant effect. Now, what that reflects, Your Honor, is a rich literature, psychological literature that we're prepared to put on testimony about, having to do with the naivete that lay people have, many of us have, about statistics and about how easily people can be confused and misled and prejudiced by the presentation of statistics. There's a rich literature in this field. And what will not ordinarily be understood by people is that if you have a false positive error rate, for example, of 1 in 200, or 1 in 243, I think was the last one that Cellmark offered for itself, then the chances, for example, that a particular test result is a false positive is 1 out of 243. And the gene frequency of 1 in a billion is irrelevant, or so we would argue, or at least people should understand that argument or understand that it's one that's available to them. Now, they have to understand that distinction, and they shouldn't be confusing the gene frequency statistic with anything other than what it is, and be free to understand and consider the other evidence in the case. And it's critical that jurors understand that.
All right, good morning, counsel. Back on the record in the Simpson matter, Mr.
All right, guys. In almost exactly 24 hours, minus 17 minutes, we start the marathon. So what I need y'all to do is go to bed. Just wake up for Bill's stream, but go to bed and sleep as long as you can. And then we'll see you all in 24 hours. There's no stream tomorrow morning. There's no OJ stream tomorrow morning at 8 a.m. my time, which is exactly 24 hours from now, minus 17 minutes. We start the marathon. I hope to see you all there. I hope you guys have a great, great, great 4th of July, no matter what you're doing. Be careful with the fireworks, please. Please. And be careful with the alcohol. Thanks for coming out, guys. I really appreciate it. I'll see you all again real soon. Bye.